Good morning, everyone. Here I'm Pilvinder Kaur. Here I'm representing group number 2, in which we are total 6 members, including me. Pilvinder Kaur, Ramandeep Kaur, Rubal, Rakhi, Manmeet Singh 436, Manmeet Singh 437. And we all have worked very hard towards the case study which was given by our respected Sir Roger Batchelor. The case was between James Chenwick Rankin, carrying on the business as Rankin Garage and Sales, he is the appellant, versus JJ by his litigation guardians, who are the respondents, and Ontario Trial Lawyers Associations and Justice for Children and Youth, who are the interveners. So, in this case, we will learn about the judiciary and law system, which was analyzed. And this assignment is selected, as I have told you before, only Rankins and Rankins Garage and Sales versus JJ and C. And this case is this case of injury and accidental events, which is briefly described in many parts, which my group member will explain you in details. First of all, you will find facts on the facts and factual which me and my group member will talk about, and after there are the issues which were held and the holdings. So starting from the facts, in this case there were total members are like the main character of the case is J, which was hurt in the incident which took place. By that only the case is invented. And the main character are two boys, J and C. C is J's friend. After that, R is Rankin's garage owner or Rankin's garage. This case is also involves C's mother, who is also a crucial character, or we can say a part of this case, as she is equally involved and responsible for the incident, because she does not care about her child and she does not took care of them, and as they did the illegal activities like smoking, drinking, and driving without license, which is very illegal thing. After that, the minor injuries are illegal nature, may not be punishable, as we know that the things which we do when we are minor, we just do in our hype and we does not care about them. But as they are not punishable, but they are crime, and they also cause many effects. As per the report Shahid 2021, there should be perfect duty of care for that mother. That means the litigation guardian of J, who was injured in this incident. Now I will request Ramandeep Kaur to represent the next facts and factuals of this presentation.
Hi everybody, myself Ramandeep Kaur. Here I'm going to discuss about the facts, like the brief about the factual events leading to the judgment of this case. The jury found all parties, including J, negligent and proportional damage, like 37% to the Rankin's garage, which is R, and 23% to the C, and 30% to the C's mother, and 10% to J. The jury relied on the following particulars of negligence. The vehicle was left unlocked with the keys in it, where the garage knew or ought to have known of the potential risk of the theft. So the garage had provided very little security, and there were testimonial inconsistencies on the part of the garage personnel as to their like policies and practices. So J sued over R and C and the mother. That is the main fact in this case. So the facts I'm discussing, sorry. So here is some facts, like events leading to the judgment of this case. First is the Ontario court, which is the main. The Ontario Court of Appeal upheld the decision, but concluded that the trial judge had erred in concluding that the duty of care had already been recognized in the law. Thus, the Ontario Court of Appeal treated this as a novel theory of negligence and applied the two-part uh, test out in NSV Meryton London Borough Council. So, and Cooper v. Hobart 2001 SCC 79, the Court of Appeal held that there were sufficient foreseeability of harm and proximity between J and the garage to support a duty of care. So the Court of Appeal reasoned that since the business commercially stored many vehicles, so it is the responsibility of the garage owner to take care of their vehicles. So it had a responsibility to secure them against the theft by minors. So in whose hands they would be dangerous. The Court of Appeal concluded that uh, a general risk of theft include the risk of theft by minors. So Anna Cooper test by Huscroft JA has highlighted the prima facie duty of care has been neglected on the court has dismissed the appeal. So next slide has been followed by Rubal.
Hi, my name is Rubal Arora. Here I am going to talk about the issue of this case. This case showed that Rankin Garage argued before in court that someone would steal an automobile and in a workshop. This argued that the victim has driven it riskily. J. Unlawful behavior could show that in many circumstances, and of the direct link between the parties are doing these things of the in that case obliging with care. Moreover, J condemns the notion and the Ennis Cooper testing, forecasting, promotion lacks an executive limit of this case. This makes it reasonable that young people lacking experience steals cars. This also state ranking garage proactive responsibility to prevent child and ranking garage was obligated to take extra precautions to keep kids safe from harm if they stole a car and ended up in the collision. This garage is responsible for strong goods which are the dangers in hand of the minors of this mistake. The circumstances such as the dangers of personal injuries are enforceable. Moreover, commercial garage has a potential duty to guard against thefts by minors. Illegal incidents have been conducted with this proximity to prima facie responsibility. Moving further of this case show that every descriptions have concluded all complicants indicates toward the duty of the garage. In this concern, J has the complex of all the incidents which not be responsible for such a case. One of the main issues show that in the case is that R and has on J of the duty of major responsibility. Next slide will discuss Manmeet.
Hello, my name is Manmeet Singh and my student ID is 4364486. And today I'm going to talk about the disputes of this case. In this case, suspect J as the main culprit as a major injury was received within C. And her mother was also one of the responsible people for the incident as she has no responsibility towards her child. Next slide, please. And now I'm going to talk about the holdings of this case study is that the town of Paisley, Scotland is home to what is arguably the most well-known negligence case in history. Donahue v. Stevenson established an orderly method for the growth of carelessness, misconduct, and it completely changed the law of torts. And moreover, There are more holdings that are followed by this case study is that the garage needs follow legal registration and property security. In the present setting, Lord Atkin is most known for having articulated the neighbor principle, namely holds. And the neighbor principle is in this area is a vital aspect that has an impact on the society nearby. Thank you. Now I would like to request Raki to continue.
Hello everyone, my name is Rakhi. Here I would like to talk about the holdings. The law can made an obligation to provide care towards an individual. This is the property of the art that is not well defined in Canadian court decision. This is an interesting point about the obligations to provide care towards the individual in Canadian court discussions. The property of art that you mentioned might not have a well designed definition. It is possible that the specific interpretation and or application of this property in Canadian law is still evolving or not yet firmly established. Legal concepts can sometimes be subject to interpretation and further clarification through subsequent court cases. Next slide, please. Sorry. The court has stated the garage need to improve their responsibility for making protection within the garage. Some careless activities of the court towards property in society has resulted in disciplinary matters. Thank you, and Manmeet will present the next slide.
Uh, Hi, my name is Manmeet Singh, student ID 4374841, and I will elaborate the rest of the holdings part. The court said that the garage needs to do a better job of keeping people safe inside. Furthermore, the court's careless behavior towards property in society has lead to disciplinary issues. Uh, mo- uh, Moving to next slide. The careless behavior seen in this case has made things worse and create problems for the garage. Adding to it, people should take care of their property and make sure it's registered with the government, which may ensure the security of the property. Moving further, uh,
So here is the reference list, which are included in this case studies. So thank you so much everybody for joining us.